But let's
Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. Pacific time here on the Bottled Business Sense show. Welcome. I am Rick Moscoso, one of your co-hosts here. And I have Bill Bernard on the other side in our Hawaii location. We were talking off air just a short time ago about a really important a topic. And before we get Bill to expand on that, I just want to pull him. Bring him here on air and introduce him real quick, and then Bill, you can roll right into it. So, welcome to the episode, Bill. This morning, how you doing?
Thank you, guys, and glad to be back here with you. Sorry, I'm just putting the phone on vibrate. Man, I get these calls coming in all day, and so I don't want to have the show disturbed. Anyway, Rick and I were talking. This is something that I have a lot of experience with, and it's something, and this is. This is going to be in the area of employment law, and this is something that is extremely, extremely, extremely important for both employers and employees. And it's entitled, "What is a severance package?" There's been a lot of questions about this, and there's going to be a lot of overlap in the way the law used to be and the way the law is now. So I wanted to present this to everybody to make sure you know what you need to do and what's involved in getting a severance package should you be let go from your place of employment. So let's start with the simplest of the terms here. What is a severance package? Well, a severance package or agreement is an enforceable contract, okay? It's between the employer and the employee upon termination, and the employer provides the employee with a certain amount of money or wages in exchange. What I mean by that is the money is the wages, same thing. In exchange for the employee releasing or waiving his or her right to sue the employer. So that's it in its simplest terms. It's a contract. It's between the employer and employee, and the employee gets money or wages, same thing, and the employer gets a waiver of a right to sue. How it comes about is that there's a conflict in the workplace that the employer or the employee knows is building up to something that could possibly involve litigation or some sort of mediation or arbitration. And in the other scenario, we have an employment contract where somebody is hired under an employment contract, and it's already set out in that contract that should the employee be terminated in some fashion according to the terms of that contract, him or her will receive a severance package. So those are the two scenarios in which a severance agreement will rear its head. What's important to know, and this is one of the crossovers I spoke about, remember employment is at will in California. You can be fired at any time for any reason or no reason at all, unless you're fired as a result of discrimination, retaliation, or if you have a contract of employment that specifies the specific instances in which you can be fired. In other words, reasonable cause. So those are the three instances in which at-will employment does not occur. So right now we're going to be talking about at-will employment and a contract situation where an agreement is reached between the employer and the employee in terms of severance. Anything you want to know about discrimination or retaliation, we have a lot of videos on that. We've done shows on that before. I update that periodically in new shows, and we'll continue to do that. So you can look for that on our website. Okay, so let's get into it. Is a severance package mandatory? No. No state or federal law requires employers to pay severance to employees when they are discharged. Now, there is a state agency called the Division of Labor Standards Enforcement, otherwise known as the DLSE. These are where people go to file claims, and you don't need a lawyer to do this. You file a claim when it involves a dispute concerning wages, whether that be vacation, whether that be overtime, whether that be just regular wages. Now, the DSLE is authorized to hear claims involving severance. But if the rights to a layoff or severance pay are set forth in the employee handbook, if there is an employee handbook, or there is some sort of a policy that the employer institutes concerning severance, then that's going to resolve the issue. In other words, you only go to the DLSE if you have a dispute about wanting severance pay where the employer has no policy covering severance pay. So for our purposes today, we're going to assume that the employer is offering severance, that there is a severance package being offered to the employee, and we want to find out now how the employee is going to proceed. By the way, before I go further, it's interesting to note that in various studies, there have been several findings concerning human resources departments have done studies concerning severance packages. And it's amazing that 55% of those companies that were interviewed had formal policies, with the majority of them communicating their severance policies by way of emails or some sort of bulletins or policy that they have. So this is continuing to grow because severance packages are a way to avoid expensive litigation, and of course, it's becoming harder at times to really get an employer and an employee on the same page. Now that involves how do you make your employment area safe and communicable and a place that you want to work in. Those are all different issues, again, that we've covered before on other shows. But assuming that heads are going to knock, severance packages are a way to avoid all this expense. Not that the employer won't have to pay out something, but the employer gets something in return in the sense that the various claims against him or her are waived. So, employers typically offer severance agreements in exchange for a full and final general release signed by the employee. So let's look at this. For example, an employer and employee may have had a dispute over wages, and the employer may have decided to provide a severance package to put closure on the dispute and ensure no further litigation would arise in the future. However, employers cannot condition the payment of wages that they have admitted owing the employee and put that as part of the severance package. So, Rick, you're my employee, and I don't like you anymore. You don't like me. You know you're going to get canned, and so we agree to have a severance package. If you know that you have wages owing you, and I've acknowledged that those wages are owed you, I can't use that as a bargaining chip in a severance package because those wages are owed you. And if you have a dispute about those wages, you go to the Division of Labor Standards Enforcement. That's what they're there for, to handle wage claims that are acknowledged, that are owed you. What is important is to know that if a bona fide dispute exists over wages, however, then that can become part of the severance package. So you say you're owed, $1,000. I say you're only owed $900. So I'm not saying to you that, yes, I owe you the $1,000. I'm disputing what I think I owe you. that can be part of a severance package whereby we agree to resolve the claim so that there's no litigation. Okay? Now, that's just a little piece of what can comprise a severance claim. I'm going to get into the real nuts and bolts of it in a second. And that is 1542 waivers. That's a term used by attorneys. There is a Civil Code section 1542. And what 1542 says, and this is always a big part of a severance package, that's why employees need to be aware of this. 1542 is a provision that was put in place by the state legislature to ensure that claimants or employees do not inadvertently waive unknown claims. So when I say to you, Rick, I'm going to pay you X amount of dollars and you're not going to sue me, you're agreeing not to sue me for certain things that happened in the workplace that we speak about and have acknowledged as being a sticking point between us. But you may have another claim somewhere along the line that has nothing to do with the dispute that's causing your termination. And you have a right not to waive those other claims. 1542 waiver is put into the severance agreement, so it says, yes, you do waive any and all claims you have against the employer. What do you think the reason for that is? The reason for that is because the employer is going to give you some money, and he doesn't want to look over his shoulder and say, well, maybe he won't sue me about X, but he may sue me about Y. So employers' attorneys put in 1542 waivers, meaning we're getting rid of the protection that 1542 offers. You're waiving anything and everything that you may have against that employer in exchange for the money the employer is paying the employee. So that's a 1542 waiver. And it's typical. It's not something that someone pulls the wool over somebody's eyes. It's always inserted in there. And the employer has to have that in there because otherwise, like I said, you never know what an employee can do. Somebody can sue you at any time for any reason, which is what we've preached on this show for how long, right? You don't have to be in the wrong to be sued. You might get rid of the case, but in the meantime, it may cost you money. And if there's not a provision for attorney's fees, you're going to have to pay your attorney to defend that bogus lawsuit up until the time it's disposed of. So a general release does not extend to claims which the creditor does not know or suspect, the creditor being the employee. How do we get rid of those? We have a 1542 waiver in there, so all claims are disposed of. Signing such a waiver, here's the other part now. Remember, this is all going towards this severance package. Signing a 1542 waiver agreement significantly impairs a plaintiff's claims or precludes them from bringing a lawsuit entirely. However, there are certain claims that even with a 1542 waiver cannot be waived. Isn't the law fantastic? I mean, it's just, you're just zigging and zagging all the time, you know? So here's the deal. Workers' compensation claims. If you were injured on the job at some point in time in your employment and you have a workers' compensation claim, and of course, California state law requires employers to have workers' compensation insurance, you cannot make that part of the severance package. That cannot be waived. That has to be either litigated or resolved through mediation or arbitration or some other form, because the insurance company that the employer is paying to insure them pays out on that claim. So that cannot be waived. Number two, claims where the employee is seeking reimbursement from an employer for the purchase of supplies or any kind of costs related to the job. If the employee had to defend a lawsuit, for example, where the employee was sued by somebody else, those cannot be waived. Those claims have to be resolved independently. Number three, claims for unpaid wages or overtime. We mentioned that before. If it's not in dispute, the labor board can hear it. If it is in dispute, if it's not in dispute, it can be used as part of the severance package. If it's not in dispute, it can't be waived. I owe you $1,000, Rick. I agree with that. That can't be part of the severance agreement. Rick says, I owe you, you owe me $1,000. I say I only owe you $800 or $900. That's a dispute that can be put as part of the severance package. And finally, number 4, claims for unemployment insurance. If there's a claim involving your employer's unemployment insurance, that cannot be waived. Now, you can waive all your civil rights claims, right? So sex discrimination, age discrimination, race discrimination, those are all part of the 1542 waiver. Remember, the 1542 Civil Code says you're protected against other claims. 1542 waiver, which is part of the severance package, says those claims are out the window. You're no longer protected because you're waiving your 1542 rights. It is imperative that if you have a labor lawyer review the severance package. And typically in every severance package, it has a big bold print in there that says you have X amount of days to have your lawyer review this, and you acknowledge by signing that your lawyer did review it, even if you didn't have a lawyer review it, which you should. Because you're releasing important claims, as I said, and there may be terms in that severance package that are illegal or it could be terms in the severance package that are illegal. The employer is trying to dupe you. Or it could be that you want to revise some claims and your lawyer has some ideas about how to revise these terms, I should say, not claims, but the terms of the agreement. Very, very important to have a lawyer review this agreement. Can't say that enough. Severance pay constitutes wages for purposes of the Labor Code. That means it requires an employer to pay all wages earned by the employee on his or her final day if they are discharged, or within 72 hours if they voluntarily resign without providing 72 hours notice. The code provides penalties in the form of a day's wages for every day the employer is late in paying the final paycheck. So when you get this severance package from your employer, it constitutes wages. And guess what? If those wages aren't paid in a timely fashion, pursuant to the Labor Code, and it better be in the agreement that says that, then now you do have a dispute that the Department of Labor Standards Enforcement will hear, because it's a wage dispute, because your severance wages were not paid on time according to what the agreement said. So if the agreement is followed, the agreement controls. But if the agreement is breached and your wages aren't paid in a timely fashion, then you can go to the labor board. So if an employer fails to provide unconditional severance pay pursuant to the employment agreement, you may receive waiting time penalties when you go to the labor board. So you'll not only get your wages that you were promised pursuant to the severance agreement, but for each day that the employer doesn't pay you, each day after the day he or she was supposed to pay you, you get a day's wages on top of that, whatever you were being paid before you were terminated. Very important. Now, employers typically provide a liquidated damages clause for attorney's fees for the person has to enforce the agreement. So one person breaches the agreement, now you have to go to either court or arbitration or mediation because it's a contract, so it'd be breach of contract, right? Mm-hmm. That liquidated damages clause that says if you breach the contract and I have to enforce it by going to someplace else to do so, whatever I incur as fees, you got to pay me because you breached the agreement wrongfully. Now, if the other side was wrong, well, then that's a different story, right?
Right. All right.
One important thing about these severance packages, Rick, if you're over 40, employees over the age of 40 are protected by the Federal Older Workers Benefit Protection Act. Boy, that sounds like a mouthful. You know, it makes me feel old, right? It requires that enforceable settlements of age discrimination claims follow specific standards. So what that means is this: if you're over the age of 40 and you're signing this 1542 waiver as part of your severance agreement, the employee must have 21 days to consider the release and has 7 days after he or she signs it to revoke it. So I've got 21 days to examine it. And then when I sign it, I've got 7 days to revoke it. That's if you're over 40 years of age and you're entering into a severance package. If you're over 40 years of age, and this would go for any severance agreement anyway, the release must be in writing and must refer to the Age Discrimination in Employment Act of 1967, which is another act which is called ADEA, A-D-E-A. The written release should always encourage an employee to seek legal assistance. I'm going to keep mentioning that. Now, to end this show, people may ask, can I negotiate the terms of my own severance package? What do you think my answer is going to be, Rick?
If you're defending the employee?
No. Can I, me being the employee, can I negotiate the terms of the severance package with my employer directly?
I would say no.
Well, you can, but you
shouldn't.
You shouldn't, right.
Right.
Hire a labor lawyer to facilitate and negotiate California severance pay on your behalf. That can help significantly, because here's what the lawyer is going to look for. 1, was a written severance pay plan part of your employment contract? Was there a policy? I want to know that. 2, what have other employees been offered in similar circumstances? Maybe other employees have been terminated under the same conditions. What'd they get? An attorney can stick his or her nose in there and try to find that out. Number 3, how much room is there for negotiation? Maybe you want more money that's being offered to you by the employer. Number 4, was an offer made by the employer prior to the attorney being retained? The attorney wants to know that, because that will help him or her understand what he or she is getting into as he or she moves forward. Number 5, can a structured payment be made so the separation date is extended and the employee continues to receive health insurance or pension benefits, right? So maybe you want to make this severance package extended over time as opposed to one lump sum, because you want to continue as part of your severance package, your negotiated settlement, if you will. You want to continue to receive either pension or contributions to a pension plan, or maybe health insurance. Very, very important stuff that a lawyer can help you with. And finally, number 6, what is the current financial health of the employer? If payments are made over a period of time instead of one lump sum, like I just mentioned, will the employer be insolvent? If the employer's having problems, the attorney's going to want to know that. Maybe that will persuade him or her to opt for the one lump sum payment and say, hey, don't worry, Rick, about your insurance premiums. There may not be a company here in a few months. All of these are very, very important things to consider and are part of a severance package. And so I wanted to make sure, in light of the questions I've been getting recently, that people understand the involvement in a severance package, both from the employer and the employee perspective, how important it is to have a lawyer on board with that, and how you're entitled almost nowadays to some sort of a severance package. I wouldn't say entitled maybe, but it's leaning more in that direction. But the important thing you must remember is that you're waiving your rights in exchange for this money. And that means one thing. This is more than a severance agreement. It's more than a severance contract. It is, in fact, a settlement agreement. You are settling out of court a potential claim that you have against your employer in exchange for money by waiving whatever rights you may have against that employer. So that's it in a nutshell, folks. I hope maybe you've taken some notes. If not, they can always go back and re-listen to our show. And where can they find that, Rick?
Oh, absolutely. You can always find us on bottledbusinessshow.com on our website. We have a whole host of previous episodes there where you can rewatch this one as well. We're also on Twitter and Facebook and also LinkedIn. Just go ahead and search for Bottled Business Sense Show, and we'll come up in those 3 areas. So,
and you can also go directly to YouTube, right?
Oh yeah, you can go directly to YouTube to Bottled Business Sense Show, or even try BBSS, and you'll see us there as well. Our entire library from the past 5 years are on there. So,
if you go to my website, one second, Rick. If you go to my website, which is wfblegalconsulting.com, there is a drop-down box there for the Bottle Business Sense show. If you happen to be on my site for other reasons, you can click on that, and that will take you directly to our videos, and you can watch it from my site as well. Yeah. What were you going to say, Rick?
Absolutely. And then if you have any questions for Bill, myself, or the show, you can enter that information, the contacts below this video. Reach out to Bill, myself, or the show itself at bottlebusinesssenseshow@gmail.com. Or if you have more specific questions in regards to Bill's expertise or my expertise, our contact information is there as well. I wanted to share with you just something. I got a call earlier today from I had no idea where it was coming from. I saw a call coming in from Kentucky. And it was a client who asked not a client, but a viewer who was actually had watched one of our episodes, not sure which one because I haven't had a chance to speak with her yet, but she said, I saw you on YouTube on one of your episodes, really liked it. I don't know exactly what I'm looking for or how you can help me, but I really would like to strike up a discussion with you to see how you can help my business. So that's going to be an interesting conversation.
Fantastic. And you mentioned that, Rick, and I don't often toot our own horn here on the show, but in the past 3 weeks, I've gotten at least 7 calls from various people who watch the show and who want. Now I always tell them I can give you bits and pieces and tell you what I would do if I were you as a layperson. I can't give you legal advice unless you retain me as your lawyer, but I help them to the extent where I basically say, hey, if I were you and I was not a lawyer, here's what I would do. And I try to help them as much as I can. So yes, those calls come in a lot, and I'm proud of that, as I know you are, and I'm happy for viewers taking advantage of the information we provide for free to them.
Yeah, absolutely. Just, even if it's a simple question, don't be afraid or hesitant at all to reach out to Bill or myself. We'll be happy to at least give you some direction. And we won't know unless you reach out. So please do so.
Yep, absolutely.
All right.
Well, with that, we will see you on our next show. And in fact, as a result of some traveling we're going to do, or I'm going to do, we're going to tape that show right now after you watch this show. And so if you see me in the same shirt, you'll know that it's not because I have 2 of them or I wear the same shirt every day. Okay.
All right.
So anyway, I'm glad everybody tuned in, and thanks for being here with us and supporting us. We appreciate it.
All right. Thanks, folks. We'll see you on the next episode of the Bottled Business Sense Show. Take care, everyone.